Good morning, everyone. We'll be starting in just a few minutes. We want to give a couple of minutes to some late arrivals. So if you'll just hang tight, we'll begin the presentation in about 2 minutes. Thank you. What did I do?
Everybody still there? Joy?
Yes.
Yes, still here.
Okay.
Good morning, everyone, and thank you for joining us for the latest edition of the Wolfe Webinar series. I'm Joy Osborne, Director of Support for Wolfe and Operations Manager for the Background Screening Division. We're excited today about our webinar's topic, Hot Topics in Background Screening. We're going to be asking for question and answer and having a period at the end of the program. So if you'll submit your questions in the question box to the right of the presentation box, then we'll address as many as possible toward the end of the presentation. We will be sending a recorded version of this presentation to all attendees in just a couple of days after the presentation. We're very privileged to have today as our presenter, Pamela Devada. Pam is a labor and employment partner at Seyfarth Shaw. She's a subject matter expert on Fair Credit Reporting Act and state laws affecting background screening. She counsels both employers and providers on background information on compliance requirement, as she's been involved in hundreds of single plaintiff lawsuits and numerous class action cases regarding these issues. She actually even testified before the Equal Employment Opportunity Commission about the use of credit checks as a screening tool for job applicants, and she's appeared twice on the morning show Fox and Friends discussing this topic. So we're very privileged and happy today to have Pamela with us. So at this point, I'll turn it over to you, Pamela. Welcome.
Thank you so much, and welcome, everyone. I'm thrilled to be here today with Wolfe to talk a little bit about hot topics in employment background screening, and specifically how to mitigate your legal risk with regard to the world of background screening. What we have seen is a huge increase in the amount of lawsuits that have been happening both against employers and also against consumer reporting agencies. Needless to say, the plaintiff's bar is very focused on the issue of background screening and specifically with the Fair Credit Reporting Act. Before we get started into the substance of today, wanted to let you know that this has been prepared by Seyfarth for Wolfe for informational purposes only, and although I am a management side attorney, nothing that I say today is meant to be legal advice or counsel on behalf of myself or Seyfarth Shaw or of Wolfe, and understand that nothing that we're talking about today creates an attorney-client relationship, even if we may have one with your organization. In terms of my practice, that's me. We'll go very quickly over this slide, but I am a labor and employment attorney. I've been practicing for about 15 years, as Joy said. My focus is on all things pre-hire and specifically related to all things related to criminal history, credit history, and the Fair Credit Reporting Act, both on a counseling perspective and a litigation defense perspective. And as I said, we have seen an inordinate increase in the amount of litigation really in the past sort of 2 to 5 years on the Fair Credit Reporting Act. This is a 40-year-old consumer protection statute. But what we have seen is that plaintiffs' counsels are coming up with unique and novel theories all the time against employers specifically, because much like the wave of wage and hour litigation, as it was in the past and as it continues to be, these are relatively simple claims to bring. They are often cut and paste with the complaint, and they are large money dollars very quickly, because the Fair Credit Reporting Act contemplates what's called statutory damages. So instead of actual damages being sought, where someone has said, I've lost a job, for example, someone can allege statutory damages of $100 to $1,000 per person on a class action basis. And that's why you will see in the media there have been numerous settlements on the $2 million, $3 million, $5 million, $7 million recently with employers that are very, very large amounts that add up very, very quickly. And we'll talk a little bit about what's happening in the world of background screening, and specifically what's happening with some of the litigation, and also what's happening over at the Supreme Court, so that you can understand some of the cases that we're watching, which may have an impact on these cases being brought.
Pamela, I'm sorry for interrupting, but the screens are not showing, your webinar screens. Could we just check to make sure that the screen is shared?
Sure. If somebody wants to give me control again, I did hit that, but let's try again. If somebody can on your side give me control, that would be great.
Sure, Mark.
Sorry about this, technical difficulties here, guys.
We can see the screen. Go ahead.
Okay, great. Everybody can see, should be seeing the agenda screen. If you cannot see the screen, go ahead and type a message into the chat, and we'll try again. What we're going to talk about with our agenda is a little bit of an update of what's happening in the Supreme Court. That's going to be the Spokio case. And then we're going to focus on where we see the main litigation with disclosures and authorizations primarily. We're going to talk a little bit about electronic signatures, adjudication and hiring matrices, and the adverse action process, and then ban the box. As an employer, you have 4 responsibilities under the Fair Credit Reporting Act. 2 of them are very easy. 2 of them, and don't get a lot of litigation, at least against employers. 2 of them are where we see the most litigation. So the 4 responsibilities you have under the Fair Credit Reporting Act as an employer are: before you get a background check, you must have a permissible purpose to do so. Generally speaking, a permissible purpose is going to be an employment purpose in the employment sector. So if you're dealing with an applicant or an employee, you're going to have an employment purpose. That's an easy one. The FTC, the Federal Trade Commission, is one of the 2 regulators with the FCRA. The other is the Consumer Financial Protection Bureau, and they actually interpret the term employment purposes to be extremely broad. So one of the things that we have a lot of our clients ask about is, for employment purposes, does it apply, for example, to independent contractors or volunteers? And in the employment realm, we all know that independent contractor classification and volunteer classification is very important, specifically from the wage and hour view, how you pay these individuals for the services or the volunteer things that they do. From the FTC's viewpoint, employment purposes is going to encompass all of those people. So understand, if you're dealing with volunteers or independent contractors or employees or applicants, employment purposes is generally going to apply. The other thing that you need to do with regard to the 4 factors or the 4 responsibilities is you have to promise, make a certification to your employer, to your consumer reporting agency, that you as an employer are going to follow, frankly, your responsibilities under the law, that you're going to have a permissible purpose, that you're going to get the disclosure and authorization that we're talking about in a few minutes, that you're going to follow the 2-step adverse action process, again, that we're talking about in a few minutes, and that you're not going to run afoul of any EEO, equal employment opportunity laws. That usually is very easily done. It's usually done in an employment agreement with the consumer reporting agency. So you might have a master services agreement or an end user services agreement where you make those promises. You might also see that your background screening company may require you to promise every time you make an order, and that's because of some recent litigation that's ongoing against background screening companies currently. The 2 areas where we see the most litigation, though, are with disclosures and authorizations, and with adverse action. There's two other areas. So we're going to spend a large part of our discussion today talking about what that requirements are and where we see the litigation. Real quickly, before we dive into that, and you'll see how this correlates, we have been seeing a huge increase in the number of claims against employers who, for example, may have a disclosure form that somebody argues is a violation of the law. So it may have a sentence that plaintiffs believe makes it violative, like a release of liability. And again, we're going to talk about the very specific areas where those are being challenged. What has happened in the law is that there is a split in the circuit courts of appeal of whether or not, in order for somebody to actually bring an FCRA class action or an individual case, whether or not they have to be injured or wronged such that they have standing to bring a case. Standing is a legal term of art that lawyers learn about in law school. Basically, it means that they have the ability to bring a case, right? There's a lot of laws out there, but if you're not affected or impacted by them, you don't oftentimes have standing to bring a case if you're not injured or have a concrete harm. What happened in the Spokio case is that in the Ninth Circuit Court of Appeals, there was a company named Spokio, and a man named Mr. Robbins sued Spokio, alleging that Spokio had incorrect information about him that was on the internet. And they alleged that Spokio was a consumer reporting agency. Mr. Robbins did not allege any sort of harm or injury. He didn't allege that he didn't get a job, or that he didn't get an apartment, or he didn't get insurance. He didn't allege any concrete injury of harm. And so the district court said, wait a second, I'm going to dismiss this case. You don't have any harm. The Ninth Circuit Court of Appeals said, well, no, you doesn't matter if you have harm. This statute allows for statutory damages. So if there's a violation of a statute and somebody wasn't wronged, it doesn't matter. You can still get statutory damages. So this case went up to the Supreme Court on a writ of certiorari to see if the United States Supreme Court would take the case. Interestingly, the Solicitor General of the United States recommended that the Supreme Court not hear the case, which was really interesting. And we thought that they were inviting another case, but that would have to work its way up through the court system. Over the objections of the Solicitor General, the Supreme Court actually granted certiorari, and that case is in the process of being briefed right now. So the very, very good news is that right in front of the Supreme Court imminently, and we should have a decision either by the end of this year or likely early next year, we're hopeful, based on the briefing and the oral argument schedules, of whether or not somebody needs to have an injury or be harmed. And when we talk about the disclosure cases, you'll see how that's going to be potentially important, because most of the cases that we see being brought in the disclosure realm is somebody who goes through a hiring process, fills out a background screening disclosure and or authorization form, whether it's one form or it's two forms, gets a background check done, and then is hired. And those individuals arguably have had no injury of fact or no concrete injury, yet they are bringing multi-million-dollar class actions against employers who are alleged to have had something wrong with their disclosure and authorization form. And the theories keep getting broader and broader every day. So what are we talking about when we're talking about disclosure and authorization forms? Basically, the Fair Credit Reporting Act requires that before you conduct a background check or ask your background screening company to procure a background check before you, you must give to the individual a disclosure in a standalone document consisting solely of the disclosure. That seems pretty simple. The problem is the very next sentence in the Fair Credit Reporting Act then says you must also get a written authorization of the individual. And oh, by the way, those forms, even though it says it needs to be solely the disclosure in a standalone document, the statute specifically says that the disclosure and the authorization can be together. So what we have seen is for many, many, many years, most employers had a disclosure form that said disclosure and authorization. At the top part, they'd have a disclosure. At the bottom part, they'd have an authorization. And there was no problem for, frankly, the last, 40 years of this since the inception of the Fair Credit Reporting Act until around 2012. In 2012, there was a case called Singleton versus Domino's Pizza, which really was one of the first cases to attack the veracity of the disclosure form. And it did so because the disclosure form in that case had what's called a release of liability. And so in the form, it talked about that by signing the form, the applicant or employee was releasing any liability against not only the employer, but the background screening company for getting the information and or for using the information. And in 2012, the Domino's Pizza court basically held that could be a violation and make the entire disclosure violative of the law. Now, that was the very first case. We had many other cases going the other way, Smith versus Waverly Partners, and other cases that called into question whether or not a release of liability really could be a violation. What we have seen now is there's critical mass. There's been about 15 cases or so that have dealt with this. And at least now, because it is publicized, the argument is if you don't do something to change your form or your disclosure form, then potentially you could be alleged to be acting recklessly, or in terms of the statute language, you could be alleged to have a willful violation, meaning that you acted with malice or reckless disregard of the law if you did not abide by the law after all of these different cases. So if you learn nothing else from this webinar, one recommendation, again, without giving legal advice, is to make sure that you review your disclosure and authorization forms by counsel who understands the issue, whether inside or outside counsel, and make sure that you understand that there's a ton of litigation on this. I mean, we see new cases literally every day. I'm currently handling over 17 class actions alleging this exact same allegation, that the disclosure form was somehow in violation. People who do it in a paper process or in an electronic process, those are all being challenged. The other things that are being challenged is when you have state law information in your form. I think that this is a poor challenge, and we have not seen any case that has come out that's saying this. But if you don't want to be the low-hanging fruit, one thing you can do is have the state law information on a separate sheet of paper or in your authorization and not having it in your disclosure form. The key is that the disclosure has to be separate and apart. So many companies are choosing to separate their disclosure form from everything else. The other thing that people are arguing about is any other type of extraneous information. So if you're on an online application system, for example, and you've got an application and then you have a disclosure and authorization, we see many lawsuits that are arguing that that disclosure form is not solely and separately apart. So you need to do something to make sure that that disclosure form is sent separately. Maybe it's sent in an email to the person before they provide their information electronically. Maybe it's on a separate web page, for example, or there's separate and distinct information and it's given to the individual in a separate format so that you have that argument. The last thing that we're seeing is this authorization being too broad. Almost every authorization has a statement that says, I hereby authorize third parties like employers or courts or police or educational institutions to provide the information to a CRA so that a consumer report can be issued. We're seeing arguments that that is somehow too broad and doesn't encompass the quote-unquote authorization that the FCRA allows. There's been no decisions on that. I think that that argument is relatively weak, but we're seeing that a lot. So to the extent you learn nothing else, we'd highly recommend that you look at your forms. And the best practices would be considering doing some of the following that are on the screen. So for example, consider separating that disclosure form from the authorization form. Let me be crystal clear. Legally, you do not have to, but we are seeing many employers being targeted when they've got a disclosure and authorization form that is together or when it is with the application process. Some applicant tracking systems may have limitations, so understand that. They may have limitations with page breaks. So what do you need to do? Well, consider pop-ups, consider other ways to make it separate and apart so that you are considering and making sure that this is as separate and apart that it can be. Again, consider the myriad of state laws. Remember, you've got California, Oklahoma, Minnesota, New York, Washington, that all have very specific state law FCRA analogs that require you to provide certain notices. One thing to consider is putting those on a separate form, or, for example, putting those on the authorization form and having that disclosure form be separate. The later in the process that you can provide this information to an individual, frankly, the number of your class goes down. There are plaintiffs' counsels who are literally on the internet looking at companies' applications all over the place, trying to see if there are violations in their disclosure form process, and then getting test applicants to go and apply even though they have no interest in the job, just so that they can file class actions. I really like the second pass. What that means is if you've got an applicant tracking system, that you have all of the things for the application process done, and then perhaps you do a screen interview or an interview, and then only after a conditional offer, for example, that's when you have the second pass, and it just consists of the disclosure and the authorization and perhaps criminal history, but it's all separate documents. If you are going to ask about criminal history, and we're going to talk about ban the box, don't put it on your disclosure form. There's a huge issue with ban the box right now, and we will be talking a little bit about that. It's a trend in the industry. Ban the box is really when you can ask about criminal history and removing it, for example, from your application. Very quickly, because we have a lot of things to cover, understand that electronic signatures with regard to the world of background screening have been under a little bit of scrutiny recently. There's a law called the e-Sign Act, and the e-Sign Act, along with UTA, which is the Uniform Electronic Transactions Act, basically talk about when someone can have an electronic signature be recognized as an appropriate signature. The takeaway for this is that you should make sure that any document that you have that needs to be legally signed, for example, like a written authorization, complies with e-Sign, or that you understand the risks of not complying with e-Sign. There's no requirement whatsoever that a disclosure form be signed, but there is a requirement, I mean, it's a best practice, and you would want to acknowledge it, but there is a requirement that the written authorization be a written authorization, and I think there's a decent argument that you need to have that signed. The good news is the Federal Trade Commission has specifically said that disclosure and authorization forms can be signed electronically. There's a question of whether or not e-Sign even applies to these types of things, because it applies to consumers using e-Sign, and consumer is defined as someone who uses information for a personal, family, or household purpose. And of course, when you apply for a job or you apply to get a background check done, that's likely not a personal, family, or household purpose. But my recommendation is you use this as a sword, not just a shield, to say, look, we are complying with e-Sign, therefore the signature is valid, and we have got very good arguments with regard to that. The takeaway with e-Sign is to make sure your process for anything you do electronically when it comes to disclosure and authorization forms specifically, or anything else that you want to be signed, that you understand if you're complying with e-Sign and how that needs to work to be defensible. There has been a huge amount of focus on an employer's use of criminal history and credit history over the last couple of years, and I have done hundreds of webinars on that specific topic, and frankly, those are usually 1 to 2 hours in and of themselves. We're going to boil this down very quickly and then say, if you're interested in having more information about this, please reach out to Wolfe, and we can consider doing another educational webinar or providing some more information. The EEOC, the Equal Employment Opportunity Commission, is extremely focused on the use of criminal history and credit history, and have been since 1998, when they came out with their uniform selection criteria. However, back in April of 2012, the EEOC came out with their use of arrest records and conviction guidance. It is not a regulation, it is not a statute, but frankly, the EEOC has been filing many, many charges on behalf of parties. Charging parties have gone to the EEOC, and the EEOC has filed litigation on this. The argument is that your use of criminal history or credit history in the employment context has a disparate or disproportionate impact on certain minority groups, specifically Hispanic individuals, men, and African American individuals. So the EEOC's theory, even though they have had some very big losses, so for example, in the EEOC versus Kaplan higher education case, which was my case and my firm's case, on the use of credit, they were not able to prove disparate impact, and they lost, and they got sanctions against them. On the EEOC versus Freeman, it was the same allegations of criminal history and use of credit. Again, they were not able to prove a disproportionate, statistically significant impact, and so they lost that case also. But the theory is still valid, and so you'll see that there are two cases pending, one EEOC versus BMW in South Carolina, and the other is the EEOC versus Dollar General in Illinois. Both of those cases deal with issues that are in the criminal history guidance. So the BMW case deals with an acquisition, basically, or a new staffing company that came in and rescreened people who had been working in the BMW plant for many, many years. And based on a new policy, they were not hired, even though that they were fired, really, even though they had been working in some cases for many years. The EEOC said that that was not valid, and that was a disparate impact. What the EEOC says is that you need to look at the three green factors. For example, the nature and the gravity of the offense, the time alleged or time that has happened since the offense or since release of incarceration, and then the relatedness to the conviction and the job. They then talk about the fact that you need to do an individualized assessment on a case-by-case basis. If this is new to you in any event whatsoever, you should get more information. Please reach out to Wolfe and understand that that this is a hot topic, and if you choose to not abide by the guidance, you could be the next on the chopping block. With regard to credit, the EEOC has not come out with formal guidance since 1998 with their pre-employment selection criteria, but there's been rumblings for many, many years. As Joy said at the beginning, I testified in front of the EEOC in a public hearing in 2010 on this issue. We haven't seen any guidance, but frankly, the use of credit is still abhorred by the EEOC. They do not like it. They believe it has a disparate impact. There are now 10 states that specifically prohibit the use of credit checks on employers. If you run credit checks, be very, very careful and understand there's a huge amount of risk. And then there's two new laws, Chicago and New York. Understand New York City is the newest law. It is the absolute most burdensome. It has the fewest exceptions and exemptions, and it goes into effect in September. So if you are doing any credit checks in New York, you need to be aware of that and understand that it's going to be very, very hard to do so in the upcoming future. Related to the EEOC's use of criminal history and their concern with that, I talked about the Dollar General case briefly. The Dollar General case is a case that had a matrix or an adjudication hiring criteria. These things are really wonderful tools when used correctly, and that's the key, when used correctly. They are an amazing tool to bake in those three green factors that I talked about before, and it assists with consistency, especially if you have a decentralized hiring process, for example. However, these have been under fire by the EEOC and by specifically New York, because New York, for example, has a law called New York Article 23 of the Corrections Law, which is on the screen, that is not guidance. It's not a regulation. It's a statute. It's a law, and it specifically requires that employers in New York must look at 8 different factors before making a decision on someone's criminal history. It also requires that you provide a copy of New York Article 23A at the time of the disclosure, and if there's any hit on the person's record, and that you put it in a conspicuous place in the workplace. So if you are grading, for example, on a matrix, and a matrix is generally a chart. On the left-hand side, it has a list of crimes. Then it may have a time limitation, for example, and then on the right-hand side, it generally has a grade, which is sometimes clear or pass or eligible or needs review or decisional or does not meet or ineligible or red. The EEOC and the New York Attorney General have said if you have a red or does not hire or an ineligible, then that is likely going to be a violation of the law because it doesn't take into effect the factors either that New York requires or that the EEOC strongly recommends, and to take into consideration an individualized assessment. Similarly, if you've got a one-size-fits-all matrix, if you've got an adjudication or hiring criteria or matrix that is for everybody in your organization, that likely is going to be challenged because it's not specific enough to the specific job requirements for those individuals. The takeaway is very, very, very useful tools when used correctly. If nothing else, strongly consider removing the bright line rules or ineligibles and fails, and have everything be decisional or review, for example. One of the things that we see in the Dollar General case is that there was a matrix and it had ineligibles, which is one of the reasons why automatic disqualification is what the EEOC would argue. So be very, very careful about that. This is regardless of whether you as the employer apply this matrix or whether your background screening company applies this matrix. Many background screening companies are choosing not to grade ineligibles or fails because of all of the litigation with the EEOC and the New York Attorney General, and also because background screening companies have been called into question and under scrutiny, again, under a very novel, unique theory by some plaintiffs' counsels when they grade, meaning that they're decision makers. So make sure if you're going to use hiring guidelines and matrices that you understand them, you understand the risks, and you understand the benefits. So now we're going to turn to the other area that we see the most litigation in the Fair Credit Reporting Act context, and that is the adverse action process. I told you before there were 4 specific requirements under the FCRA, the permissible purpose, which is employment that we're dealing with, and understand that the disclosure and authorization requirement and the adverse action requirement, the 2-step adverse action requirement and the certification requirement are only required if you are an employer using this for an employment purpose. You still have to have a permissible purpose under the law no matter what, but if you are not in the employment space, for example, then these specific requirements wouldn't apply to you. But assuming that we're all employers, the next area is adverse action. And adverse action is defined extremely broadly under the statute. It means any other adverse item or any adverse item of information that is adverse to the interests of the consumer. So what I mean by that is it can be generally speaking, it could be not being hired. It could also be not being promoted. It could also be not being given or put in a specific area, not being placed in a specific job, or other adverse employment action. So understand it's extremely broad. It's a little bit of a legal fiction that we can do before adverse action because, frankly, generally speaking, most people make up their mind about whether or not somebody is going to be hired or promoted or placed in a certain position based in whole or in part on a background check once they do the analysis. But assuming you follow the EEOC guidance and you have done a case-by-case analysis, the requirement for the Fair Credit Reporting Act is that before you take adverse action, so before you tell a person, before you code them in the computer, before you make that decision or hire someone else, for example, that before you take any adverse action based in whole or in part, so even if it's 1% based on the background check, that you must provide that person, that consumer, with a couple of things. One, a copy of the background report, not just a portion of the background check that you're looking up, but the entire consumer report. 2, a copy of a document called a Summary of Your Rights under the Fair Credit Reporting Act. This is a document that's published by the Consumer Financial Protection Bureau and gives the individual many of their rights under the law and informs them of their rights. And then you must give any state law rights. So New Jersey, Washington, and Massachusetts and New York all have very specific requirements of state laws rights that you have to provide. In Massachusetts, for example, there's an argument that you have to provide a notice that's called basically how to correct your CORI record by the Department of Criminal Justice Information Services. And the way the statute is written, it may or may not apply even if you didn't get CORI information. And most employers don't even get CORI information. That's a specific repository in Massachusetts. But we would strongly recommend that you provide that DCJIS notice and a copy of the criminal history policy that you have or criminal history procedure. Massachusetts is very, very squirrely, and we've seen litigation on that. That's only in Massachusetts. In addition, when we talk about ban the box, we've seen a huge increase in a couple of different states with these ban the box laws of removing the criminal history question, that they're also doing more and requiring that you have additional information on the adverse action or pre-adverse action letters. So San Francisco, Seattle, 2 counties in Maryland, Prince George's counties in Montgomery County, and then Chicago all require that if you're going to take action in whole or in part based on a background check, that you actually now have to provide the specific reason. So it can't be, here's the report, you guess what it is. You actually have to tell the specific reason why that individual is, you're considering taking adverse action. So you need to make sure that if you're in any of those jurisdictions that you customize your adverse action, because we're seeing an increased litigation in that, and those are brand new laws that are just happening. After that pre-adverse action letter is sent, basically it's due process. You give the copy of the report and you give the person the opportunity to say, is there anything incorrect or incomplete or wrong in this report? And the reason is, before you give away that job, before that person doesn't get that job, background screening companies sometimes make mistakes. It's not a strict liability statute. The Fair Credit Reporting Act doesn't mean that a background check company has to be perfect. They just have to take reasonable procedures, which is a high burden. However, mistakes will happen from time to time. And so understand that the reason it's sort of a due process. Before that person loses the job, they are given a letter that has a copy of the report, that has the rights, and they're given a reasonable waiting period, a reasonable period of time before that decision is made. The statute says a reasonable period of time. The Federal Trade Commission has said that a reasonable period of time is 5 business days. Understand that some other jurisdictions have, 7 days, for example, in San Francisco, although generally 5 business days is almost always going to be 7 calendar days. And the purpose, again, is to allow the person to say, no, that's wrong. It was a misdemeanor, not a felony. Or I don't know what you're talking about. This isn't me. This isn't my record, before that adverse action is taken. Employers fail and mess up this part, and I call this the no good deed goes unpunished. And here's how they do it. A right hand will not be checked into a left hand. So, for example, a well-meaning recruiter, it'll be a Friday afternoon and they'll get a background check in and the person's supposed to start on Monday, and a well-meaning recruiter will say, oh my gosh, this is a problem. There's no way this person can start. So they'll call the person up and they'll say something like, there's a problem with your background check. You can't start on Monday. Well, the consumer or the applicant on the phone hears that they're not going to be hired. Whether or not that's what's said, that's oftentimes what they hear. And you haven't given a copy of the report, and you haven't given a copy of the summary of rights, and you haven't waited 5 business days. So a better practice is, number one, not to set the start date too early. And number two, to make sure that you tell your recruiters and hiring managers to be trained that if a background check comes back and there's a problem and the person is supposed to start, the language that should be told to the person is the background check is still pending, because it is still pending, because legally you're not allowed to make a decision unless and until you follow the adverse action process. So very, very important. We've seen about 5 or 6 class actions just on that issue itself. The other thing is, if you hire somebody to work and they are started before a background check is completed, and now they have an egregious crime and you need to terminate them or get them out of the workplace, you can't do it immediately unless, so you have the options. You let the person work for 5 business days, even though they have a heinous crime that you know about, if they've already started working, or you have to pay them for 5 business days during the time that the adverse action is happening. So it's very, very crucial that you understand the adverse action process. After the pre-adverse, after the reasonable waiting time, only then can you give and provide the notice of adverse action, which incorporates everything on this form. It has to have very specific information about the consumer reporting agency, that they did not take the action, that they have a right to get another copy of their report, and that they can dispute the information in the report. But it's a very, very technical requirement, and employers unfortunately fall down with this no good deed goes unpunished. The other thing employers fall down on is with ATS systems. So for example, if you have an applicant tracking system and you have an auto letter that goes out to your folks that says thank you but no thanks, make sure that that is turned off if you're taking adverse action in whole or in part on a background check. Otherwise it will be a problem. And why does this matter? Well, let's talk about the penalties, and then we're going to get into the ban the box issues and open it up for questions. The reason why it matters is because there are two types of claims that someone can bring under the Fair Credit Reporting Act. They can bring a negligent noncompliance or willful noncompliance. We do not see a lot of negligent noncompliance. Those are generally single plaintiff individual cases. The reason being is because the damages that are allowed in a negligent noncompliance case are actual damages. So that's usually back pay. Sometimes it may be emotional distress or compensatory damages. And then a person can get attorney's fees. But think about it. If somebody alleges a negligent noncompliance on a class basis, what we would argue is that this person's damages are different than this person's and this person's and this person's, and therefore it takes an individualized determination of each person's damages such that we would try to fracture the class and say it wasn't ripe for a class action. And most courts would agree. That's why we do not see a lot of class action cases based on negligent noncompliance. Instead, we see willful noncompliance, because the allegation is, although the person has to allege malice or reckless disregard for the law, which is now a very high burden, but frankly, with all of the FCRA cases out there, everybody is knowing what's happening, and there's media and there's all sorts of information that plaintiffs' counsels are capitalizing, saying, look, you should have known, you should have been aware of this, and so if you knew about all this litigation and you chose not to do anything about it, shame on you. Somebody could allege actual damages, but the majority of these cases, individual claimants or class representatives on behalf of a class, just takes one person to sue on behalf of a class, alleges statutory damages in the range of $100 to $1,000 per person, plus attorney's fees, and then plus punitive damages. And the reason why these cases get so expensive so quickly is because the statute of limitations of these cases is either the earlier of 2 years from the date the person discovered or knew or should have known of a violation, or 5 years from the report. So let's take that disclosure allegation. If someone alleges that your disclosure form is somehow in violation of the FCRA with a release of liability, or it's got extraneous information in it, for example, whatever that may mean, basically the exposure analysis would be how many background checks have you run in the last 2 years using that disclosure form, multiplied by $1,000, and that's going to be the statutory damages. That is how we get such huge numbers of millions and millions of dollars for companies. Then you add another $100,000 to $200,000 for the attorney's fees of the plaintiff, and punitive damages, again, another $100,000 to $200,000 oftentimes are alleged. That doesn't even take into account the amount of money you will spend in defending the case and having your own attorney on this. So understand these damages are extremely high, and that's why we see so many lawsuits and why we're having the webinar today. All right, last topic before we get to best practices and then open it up for questions. And so I would encourage you, if you do have questions at this point, to go ahead and put them in the Q&A field, and we will try and get to as many as we can, is the ban the box. And so understand that back in 2012, the EEOC specifically said in their guidance that they strongly recommend that companies don't ask about criminal history on an initial employment application. The reason being is, in the EEOC's perspective, it's a deterrent and it's a barrier to employment. So for example, if you ask about it, the EEOC assumes you're going to use it, and they assume that people who have had criminal history in their past will be deterred from even applying at an employer if you ask about it, and that creates a disparate impact. And even if it's not job related, for example. And the way you defeat a disparate impact claim is to prove that there's job relatedness and it's consistent with business necessity. So EEOC has said this is a barrier to employment. We have then seen a huge increase in the number of states and local jurisdictions that have passed ban the box laws. Understand that the ones that are on this specific slide are for private employers. If you are a public employer, there's a whole bunch of myriad of other laws that you need to comply with. So at the state level, you've got these different states you'll look at: Hawaii, Massachusetts, Minnesota, Rhode Island, Illinois, New Jersey, and DC. You'll notice that most of those laws are very recent. They went into effect either in January last year or January this year. This is a sweeping movement across the nation that we do not think is actually going to stop. Oregon just got passed the other day. It is not into effect yet, but it just got passed on the ban the box law as well. Then you have local ordinances. So not only are the states doing this, but look at all of the different specific ordinances where there's a restriction on what you can ask about and when you can ask. And understand that these are very different depending on the state. So for example, in Illinois, where I am, you're not allowed to ask about criminal history unless and until the person has been told that they're going to have an interview. But other states and jurisdictions like Baltimore, Maryland, and the District of Columbia and Columbia, Missouri, for example, all specifically have restrictions that you're not allowed to ask until a conditional offer of employment. So understand that there are very different time periods. You need to make sure that you are complying. If you have a nationwide standard, frankly, if you have a nationwide standard, you cannot ask until after a conditional offer if you want to be fully compliant. But from a risk mitigation standpoint, think about it. If you have a broad question, the fewer people you ask, the fewer people who are going to be in a class. The other thing to do is consider what you're going to ask. Strongly recommend only asking what you need. Now, the later in the process and the fewer people you ask, potentially the broader question you can have. Although understand these ban the box laws, they talk about really when you can ask. There's a whole bunch of other laws that talk about what you can ask. So there's prohibitions, for example, in Connecticut, California, Massachusetts, Washington State, and others about what information you're specifically allowed to ask. So very, very strongly recommend that you move that criminal history question until after conditional offer to reduce your risk, if you will, reduce the number of people in a potential class, and reduce the EEOC coming after you. But make sure that you get your question legally reviewed so that you understand what's at issue here. We're going to wrap up with best practices and leave a few minutes at the end of our session to answer questions. So if you do have questions, please go ahead and put those in the question and answer box right now. In terms of best practices, number one, please review your disclosure and your authorizations form annually. Don't rely on anyone else to provide those to you. And if you have sample documents, it's wonderful. But understand at the end of the day, you and only you are going to be responsible for answering to a court or to a plaintiff's counsel with regard to that information if challenged on that. So understand that. Secondly, if you've got any extraneous information, get it out. Consider separating the forms, the disclosure versus the authorization. Again, you don't have to, but certainly you can consider doing so so that you would understand that. Separate any release of liability. If you've learned nothing else, release of liability is one of the hottest topics and I would say the low-hanging fruit on this issue. And then there's challenges to consider. So for example, applicant tracking systems, your program, your processes. Sometimes it's hard to fit a round peg into a square hole and vice versa. So you got to be careful about understanding and having your processes reviewed. Otherwise, you could be hit with a multi-million-dollar lawsuit. With adverse action, make sure you train your managers and recruiters about what to say, what not to say, when to talk to people, when not to talk to people, and how the FCRA works. Again, one comment can be a potential rise to a class action case. We don't want that to happen. Turn off your auto rejection letters to the extent that you have them on your applicant tracking systems for disclosure and authorization or background screening issues. So again, auto rejection letters are fine, but you have to make sure that you turn them off if you're taking action based on adverse action based in whole or part in a background check. If you have people in different states, make sure that you set your state law notices. So for example, all of the different states we talked about, New Jersey, Washington, Massachusetts, New York, San Francisco, Seattle, the two counties in Maryland and Chicago, make sure that you have all of those requirements met in your adverse action and pre-adverse action letters. And strongly consider not allowing people to start before a background check is run. It's much, much easier, much less expensive, much less consternation if you do not allow a person to start before a background check is run. Otherwise, you have to end up either paying them or allowing them to work, and you get into a whole lot of problems. It's a lot easier to reject an offer than it is to fire someone. Now they have access to your property, they have access to your people, and it becomes a significant challenge. And then finally, if you've got any questions, please put them in the question and answer box. My contact is there. Wolfe's contact is there as well. Obviously, they are providing a background screening services. If you've got questions or comments or need those services, let us know. And at this point, we are going to go ahead and take a look at the question and answers here. And I am having a little bit of a hard time seeing the questions, so I'm going to try here, and we'll get to the questions. Joy, any last words before we open it up to questions?
No, not at all. If anyone has any background screening needs, you can contact your Wolfe representative at the number on the slide. And Pamela, I'd be glad to read the questions for you if you need me to.
Great. I think I've gotten the panel open, so we're just going to sort of start here at the end.
All right.
All right. I think some people have seen the screen and some people have not. To the extent that, as Joy already said, you are going to be getting a copy of the PowerPoint presentation as well as the recording. All right, great. I think everybody got the slides. What liability are employees facing when choosing not to do background screening? So we didn't really talk a little bit about that. I think that's really the topic for another session, but I will tell you there's negligent hiring and negligent retention issues if you choose not to do background screening and then someone, for example, does something nefarious at a workplace. If you're in a regulated industry, healthcare, financial services, insurance, for example, schools obviously have their own requirements that you are mandated to do certain background checks. There is no specific law that says you must do a background check on a federal level, though, for example. Question, can you ever deny employment based on a misdemeanor conviction? And the answer is yes, but what the EEOC would say, number one, you have to make sure that there's no state law that prohibits you from doing so. And number two, you need to make sure that you do the individualized assessment and look at, when was the offense, the nature and the gravity of the offense. Obviously, it's going to be minor since it's a misdemeanor. Have they had multiple offenses, for example, or is it just one? When was it? And what's the relation to the job in question? The other thing that the EEOC, and again, this is the individualized assessment, asks you to look at is, what was the nature and the facts and circumstances surrounding the offense? Was the person, did the person mitigate? Have they been in anger management or drug rehab? Have they been working before or after? How old were they at the time of the offense? Was this, 10 years ago, for example, and they were 19 and now they're 29, for example? We've got another question. Are there exceptions, protections for home care businesses who do not hire someone with a criminal background check? I think the answer is, again, there are not any exceptions. It's the same analysis. And the question is relation to the job in question. If someone is going to be going into someone's home without any protections and they have a theft conviction or a violent conviction and it's recent with little to no mitigation or rehabilitation, you're likely going to have easier time showing that that is job related. Can the disclosure and authorization form be included in a new hire packet? I would tell you that you can have it done, although it's a little bit risky, and here's the reason why. If it is stapled or put into a packet, it's much harder to say that it's on a standalone document consisting solely of the disclosure. It can be done, and we have argued that, and I do believe that it can be a standalone document, but plaintiffs' counsels are arguing that if it's part of a packet, then it is not. Where can we find the summary of rights that was discussed under the adverse action section? You can certainly get that from Wolfe. You can also just type in a summary of your rights under the Fair Credit Reporting Act, and it should take you to the FTC or CFPB's website, and you can get a copy of it there. It's usually in a PDF form. Is a drug screen considered part of a background check? And the answer is it really depends. If the background check and the drug screens are compiled together, there's an argument that that is a background report. but it hasn't really been looked at since about 1998. So I would encourage you to seek your own legal counsel about your process and your background screening company's process to determine if it would. Another question, would there be a scenario where an employer would only send adverse action letters and not pre-adverse action letters? No, ever. Let me be crystal clear on this. You cannot combine the letters. If you are taking action for an employment purpose, in whole or in part, based on the background check, you must have the pre-adverse action, a waiting period of a reasonable period of time, and then the adverse action letter. Strongly recommend that they all be in writing. The statute actually says that they can sometimes be oral, but how do you prove it up? So never ever can you have one letter. You cannot combine them. Next question, in the case where we recheck current employees, do you suggest we have to complete a new authorization? So this is about evergreen disclosure forms or consent forms. And the answer is, if you're using the same background screening company and the original disclosure form is compliant, and the original disclosure form says that the information can be checked throughout the person's employment, it's fine. With all states, with the exception of California, where there's a question. And so in California, we'd recommend that you get a new form. If your background screening vendor has changed, or if you believe that the law has changed such that, perhaps you have a release of liability in an earlier form and you want to give a new form, we'd recommend giving a new disclosure and a separate authorization form. Question here, does it make sense to always find another reason to pass an applicant versus using a background check? And the answer is no, because the answer, under the law, if you 1%, one feather, one weight, decide not to hire somebody, even in part based on the background check, then you have to follow the adverse action process. A couple more questions, and then we're going to wrap up because we're almost at the top of the hour here. Can you attach the disclosure and authorization statement to the application? Again, with regard to extraneous information or with regard to separate and apart, you'd have to take a look at it, but would strongly recommend that you do not, because that is going to be alleged to be all one document. And last but not least here, if a home health care, can you use dismissed charges of theft or assault against them? Using a dismissed charge is never, ever a good idea, because that's just exactly what it is. It's dismissed. So understand that if you use a dismissal, it's very, very risky because it is deemed by the court and by the EEOC and by everyone else not to have occurred. Very, very risky, and frankly, in many states, you're not allowed to use either arrest records or dismissed records. So very, very risky. And then we'll end with this last one, which is how long does the waiting period have to be between pre and post? The answer is it depends on the factual circumstances, but what the Federal Trade Commission has said is it must be, well, the statute says it must be a reasonable period of time, and the Federal Trade Commission has said that is 5 business days. Again, it depends on the facts and circumstances, but there's some very bad case law that says 4 business days, for example, isn't enough. So we would strongly recommend that you abide by the 5 business days period. And with that, I'm going to turn it back over to Joy at Wolfe to conclude the session. And thanks very much, everyone.
Great. I just want to give a great big thank you to Pamela. Pamela, thank you for presenting this today. It's been so informative. I'm sure all of our attendees have learned a lot, and we look forward to future webinars with you.
If you would like more information on Wolfe services, give us a call at 1-800-230-2991 or visit our website at www.wolfeinc.com. Like us on Facebook, follow us on LinkedIn, and subscribe to our YouTube channel. We put out new videos all the time. Thank you for watching this video from Wolfe, your trusted source for employer solutions.